So good afternoon, everyone. After almost 2 days of conference, I find now that our roundtable has a kind of a tricky title, The Dispute Settlement System from a Contemporary Perspective. And suddenly I wonder, what is the dispute settlement system? This morning, Christian Tams rightly warned us about our tendency to focus on courts and to think that dispute settlement, speaking about dispute settlement is speaking about courts. And indeed, we realized all along this conference, if we were not aware enough that it's not the same exactly. You have many ways of settling disputes, including the first way, which is negotiations, of course. And so the dispute settlement system is probably an ideal type, which gathers all these various means of dispute settlement. But at the same time, we cannot forget that the Versailles Treaty and what followed the First World War gave birth to the first permanent court in international law, if not to mention the Central American Court, which existed for 2 years, but was supposed to become permanent but didn't last. But except for this aborted experience, I mean, the first permanent court was born after the First World War as a consequence of the system laid down by the Versailles Treaty. Therefore, whether we like it or not, in a way or another, speaking about the dispute settlement system is also considering what we have done over 1 century of this invention of a permanent court, what it is compared to what existed before, arbitration, and of course other political means of dispute settlement, and what are, in our view, the main strengths, the main weaknesses of these various systems, and for today, what are the major threats on this dispute settlement system, once again as an ideal type. And so what I've proposed is to ask our panelists some questions, calling for rather short answer in order to trigger the debate. And we all expect the audience to be able to be involved in the debate following these various questions. And if we could have a kind of very interactive conversation regarding this topic, and while avoiding what we call in France la conversation de comptoir, le café du commerce, if you prefer, but nevertheless, maybe it's also a nice way of entering into the weekend. Who knows? So this being said, I will first ask our panelists to reflect a bit on the legacy of the Versailles Treaty in terms of dispute settlement, and to ask them what is, in their view, maybe the main success and the main failure of what has laid down at this time. And they could focus notably on some issues which we can see are hot nowadays. Should we keep systems of optional clauses? What about the composition of courts? Yesterday we heard Jean-Louis Perrin saying that the Reparation Commission was not a true jurisdiction because, in fact, state representatives are not judges. But how do we assess these things nowadays? Has justice become a kind of bureaucratic endeavor which has lost its momentum in terms of thinking justice? Just thinking justice. So these are very open questions, but I leave the panelists very free to.
This morning it has been said that as a criticism to the European Court of Justice, that people are not aware of the legacy on which they are building. And I'm afraid that that also applies to the bodies to settle disputes which exist nowadays. People think that it's absolutely brand new. And traditionally, the new bodies are said to go back to the Iran-US Claims Tribunal, which, as a matter of fact, is not completely true. And I think that the grounds have been prepared by the Versailles Treaty and by the bodies which we discussed yesterday and this morning. the closest thing to the Versailles Treaty bodies, in my view, is the UNCC, where the Security Council has said that Iraq is the aggressor and therefore Iraq has to pay. However, I don't know whether I should go into the details, but I guess that that also has been one of the weak elements in the UNCC, because Iraq as the aggressor had to pay, but they also concluded that Iraq had not to be able to defend itself, that Iraq could not participate in the arguing the compensation and so on. It all was done behind Iraq's back, and Iraq had to pay. And I guess that's maybe one of the negative elements in which the UNCC has been inspired by the Versailles Treaty.
Thank you. So to go and continue what Christian Tams has stated this morning in a very elegant manner, I think that the establishment of the Permanent Court of International Justice was an achievement. It was an achievement in many respects, and Christian highlighted this sort of development of the knowledge about procedural law, the institutions, the know-how about to conduct proceedings before an international court of justice, and I think it's true. And I would say that today we argue, we look before the International Court of Justice, we look at the decisions of the International Court of Justice without paying enough credit to what our ancestors did in the 1920s. Because when you look at the statute of the International Court of Justice, it's an inheritance of what happened in the 20s. And in a way, there are a lot of novelties that were quite interesting. And then the rules, in fact. And if you think about Mavromatis, they created the Egyptian issues and so on. So that is something that I think we should stress a bit more. And having had to work on intervention before the International Court of Justice, we tried to look at the travaux préparatoires of the 20s, and that at that time they were much more open-minded about what would be possible in terms of access to justice and so on. So that would be the first point. The second point is that, and Christian highlighted that this morning, you know, it was the Permanent Court was established aside from the League of Nations, but there was still a provision, Article 14 in the League of Nations Covenant. Now, the incremental approach is that with the International Court of Justice, it has become one of the principal organs of the United Nations, Article 7 of the Charter. And that is something maybe we could go back and we could discuss with the people here, is that the International Court of Justice is one of the principal organs of the United Nations. And I think it should have a bearing on the judicial function of the court. And I'm not so sure that we have enough understood what it means. And for me, and I think the latest, what has happened in New York with the elections at the court are quite revealing. We have the word of The Hague and we have the word of New York. And it seems to me that we've not yet enough looked at the links between The Hague and New York, but we can come back to that.
And do you think, like some authors write, that New York is masculine, whereas The Hague is feminine? No, I'm just provoking you.
And I would add that Geneva is transgender.
So my question is, The Hague feminist? Just am I missing something? No.
According to some feminist approaches to international law, this is an analysis which has been performed. Thus, my question. I mean, I was just repeating a question that I've read somewhere. So I was just provoking Laurence deliberately on this. But this was interesting, this idea of two worlds, and the world of justice and the world of the rest and politics.
They could live apart.
Yeah, exactly.
Yes, so I'll probably make two remarks that one has to do exactly with what was said right now. And to look forward, we need to look back. So I think, I mean, if the question is what the Versailles Peace Treaty has done to dispute settlement, my personal response would be not much. But in parallel to the Versailles Peace Treaty, before and after, a lot happened in dispute settlement. So we need to know the before. You know, it's a series of events, consequences, etc. So you need to go back to the Hague conferences, I'm sorry, and everything was put there because we've heard about commissions, tribunals, procedures. You're right that we've just talked about the court. And I see that's an example of how we're court-minded as internationalists. So, and to bring to a little light, to shed into a little light in what's happened today or what happened in New York a couple of weeks ago. When the Tsar in 1899 and 1907 decided to convene the conferences, it was for disarmament. States that at that time didn't want to they hadn't thought that they were going to talk about arbitration. And there was the specific movement that was building, that was civil society at its best for me. That was revolution live for me, that era, which was pushing, and they managed to persuade intellectuals who were also diplomats. We've seen that in the European journal. It's been very much portrayed, to put it in the agenda, and it was put into the agenda. And why wasn't there a permanent court in 1907? Now, this is my point of view, Hélène, so you can, shoot me if you want to. Why? Apparently, because I read about it when I was younger, but one of the reasons why was that at some point, states were squabbling about what would be the composition of this court. And when I think of what happened in New York 2 or 3 weeks ago, this just came back to me. They were the big powers of the time. I don't know, I'm not saying names, We're saying, well, there should be some permanency, some of the big powers. Other powers, were they small at the time? I don't know. We're saying, no, hey, equality. And we talked about inequality the other day. And 3 weeks ago, we've seen people saying, hey, this institutional design, I'm not sure. You have two organs, one's a restricted P5 type oriented, and then you have the General Assembly, the populace. You have new states. They're saying, hey, me, why not me? And for me, this was something, I don't want to go into it more, but even this was something that had been fought about at another stage of diplomacy. And the second thing I want to say before just giving the floor again is that what you said in the beginning, that of course we tend to turn to the court, but we're forgetting other methods, and they exist, and they've been working, and everything has been working more or less. That's my opinion. Terrible things happen, always, tragedies. We had a Second World War, so it didn't work, the system. But, pierre by pierre, not Pierre you, but, stone by stone, we sort of build something, and we need to see where this can go.
Yeah, but nevertheless, when you speak about composition, we can just notice that the International Court of Justice is not the only court or quasi-judicial body which is affected by this problem of composition. And so if you look at the appellate body of the WTO, you could see there, a policy of undermining the organ by not appointing members. And we have other experiences on the regional basis in the South African tribunals. So courts can die, can disappear, or can be completely transformed. And so this is why I mentioned at the eve, what are, in your views, the main threats on courts nowadays, and what should be our attitude? No, I do not intend to be prescriptive, this is not the point, but maybe because we are reaching another era where dispute settlement will not depend on courts, maybe for a while, or would that be really a pity? What would be the downsides and maybe the advantages of these new situations? And so,
when I think about Iran-US Claims Tribunal, it was established, and people at the time thought that they would have done their job in 6 months. And now, more than 30 years afterwards, they are well and kicking alive. I think that, and maybe that's an approach we should have, is the function approach. Versailles, the Tribunal Arbitral Mixed did their job. And I guess the international community has been conscious that, thanks to the Versailles, that one has to establish mechanisms which do their job. And I guess maybe that's the biggest lesson we can have from Versailles. Maybe not the model and how things are structured, but just one should create things which do their job. If those things are temporary, tant mieux, and maybe it's better to have temporary items which function than permanent items which do not function. I'm thinking about the Yugoslav Tribunal and the International Court of Criminal Court, but I will not go into the details.
So maybe one thing that I was looking at my notes because I had to think about, the system, writing a rejoinder for an article that I wrote about plurality of courts and tribunals. And I think when we think about what we have achieved in the 20th century, the timeline is quite short. In fact, it's 80 years, 90 years. And this gives you a sense also of the fragility and the vulnerability of all these institutions. I think the 20th century is going to be known as the century for judicial mechanisms established on a permanent basis or semi-permanent basis. I think that what we've seen is so far is that there is trust in third-party judicial settlement. But on the other hand, we've seen that these institutions are very vulnerable. And so we have had several examples, and I was thinking, we have this crisis of the appellate body, and we might come back to that later on. But I looked at what happened on the side of the inter-American system of human rights. And there, I think we also have to take into account that this is a very fragile system. Some of the Latin American countries have sort of denounced what is going on. And one way to sort of curtail the ability of this judicial or quasi-judicial mechanism is not to pay for the resources which are needed for these institutions. And maybe that's one thing that we have creating the judicial institutions in the 20th century. We've looked at them from the perspective of global public goods. They're important for all of us, but in a way, it's global public goods for which the international community should pay its dues. And this is something maybe that we've not yet sufficiently developed and guaranteed. The other element which I think is important is that the political interferences with the judicial functioning of these things. And looking, for example, at the International Court of Justice, it's sure that the court is very much aware of the political environment. But should it be really aware of this political environment? It's the same for the appellate body of the World Trade Organization. So that also is something that we should think about, is that how to sort of carve in a better way the relationship between the politics, the political power and the judicial power.
I think one thing we should keep in mind is that all these creations have been made by states. Okay, nothing has come from. It's states who decide, for example, that they want to create more courts or commissions or supervisory bodies to talk about other forms of quasi-judicial settlement. So, and this we tend to forget, but sometimes now states who have accepted all these compulsory, because they're accepting more and more in fields of the environment and specialized fields, sometimes come back and say, hey, okay, but what's your mandate? We've seen this recently in the Human Rights Committee, for example, where states parties who created these and all these mechanisms are coming and saying, okay, well, right, but we're here, don't forget. So don't overstep your mandate. So these considerations, there will always be politics behind this, because states are the ones who create it for the moment. I don't know if we'll ever find a different way of inventing mechanisms, and as long as they're somewhere in the back there.
Yes, precisely. States are stakeholders in a way or another in the system, indeed. And so obviously they can't kill or destroy what they created. And that's for sure. But at the same time, what were just our exchanges? Aren't they too European? don't we have there a very European point of view? Is what we say European connoted, if I can put it like this? Or do you think that the ideas that we're currently exchanging are universal?
Are you speaking about the bodies who created, or what is the European dimension?
In the way, the look we are having at this court and at dispute settlement in general, what was written, it was said during our debates along the conference that the views translated in the Versailles Treaties were first and foremost European views. Do we still live with this very European model, or the considerations we are currently having now during this panel regarding the dispute settlement system, very European views? I just asked because it turns out that I participated in a panel in Asia on trends in international adjudication. And I heard some discourses about the necessity of courts and all tribunals and ad hoc or permanent to stick to their mandate, to know overstep their jurisdiction, to respect state sovereignty. So in fact, yes, you have this discourse which is very active, including on behalf of judges coming from other countries. And maybe also these values related to the idea that rule of law, which remain, whether for good or bad, a kind of reference or ideal type for the international, comes with justice, and justice comes with courts and tribunals. So we have this kind of quasi-automatic association, which we have it in our education. I just wonder if our discourse is not a European one, which does not consider other views. But it's an open question.
I'm sorry to disagree to some extent, but I'm thinking of a few things. First of all, I was involved in a commission on Bosnia on real properties. What was the origin of this commission? The Dayton Agreements, which was an agreement promoted and concluded in the United States by the United States. There was a very big American component in all the Bosnian bodies which were put as a result of Dayton Agreements. I was chairman of the Eritrea-Ethiopia Claims Commission. It was a body which was created through the Americans. I had 4 American colleagues. I was the only non-American. When, let's say, at the United Nations Compensation Commission, Canadians and Americans, even young legal staff and so on, it was really very much dominated by I would say, by American Canadian thinking. And therefore, as far as I have the impression, very bizarrely, but the modern bodies of mass claims solution have been promoted by the United States. The Iran U.S. Claims Tribunal is maybe the thing which triggered it. And the funny thing is that the United States at the moment is the party who is not too enthusiastic about those elements.
No. Wait, okay. So, yes. What I wanted to say is, I'm not sure that I as well agree. I don't know. I'm sitting on a body that has very, interesting questions of human rights. And there's a big discussion on universality of human rights. And of course, the discussion in its theoretical sphere is excellent. I mean, it's, of course, human rights are universal. But sometimes one has the impression, because you were talking about that sometimes it goes away, but for me sometimes, and this is my personal view, the impression is that these universal rights are coming from somewhere. I don't know if they're coming from the United States, I wouldn't say that. But maybe Hélène is right in a way that some of these values are coming from cultures, what we think, this old notion of the general principle of civilized, which was Western, And you don't see it. It's not very obvious, but I am not, I don't belong to a great power, so I'm just a little Greek, symbol Greek. So it's a smaller power. And I can observe, for example, that there is sometimes a disquiet by some stakeholders. It doesn't have to be states, about, don't, listen to me. Listen to my point of view as well, which is different. And to that, I want to add a very interesting discussion we had here, but maybe the young person is here who's, I think, a researcher in the house, about what, for example, the Chinese vision of the rule of law is it's rule by law. And there it means something completely different to what maybe we Europeans or consider rule of law and what international lawyers and the UN considers this international rule of law, which I don't know what exists. So I'm treading very carefully here because I can't, but, I don't know if there's what this exportation is, but yeah, I think something is there. And why don't regional courts exist all over the world? Why? Maybe it's not in, why do we have regional courts in Latin America and not in the Far East? I always had that question.
So my own perspective is that I think that judicial mechanisms are now accepted worldwide, with maybe the exception of Asia. And Asia is an important continent. There is, but Asia, you have East Asia, you have South Asia, East Asia, Pakistan, India. They've accepted arbitration for the Indus River. They have, I think you have to make a differentiation. But this put aside, I think that, and I've worked quite a lot on Africa, and maybe we can ask to our colleagues from Africa in this room also to speak about it. It's quite interesting to see that African countries have established judicial mechanisms in the field of human rights, in the field of economic integration, and so on. Now, maybe they're not working well, maybe there are some drawbacks, but at least it's seen as an important mechanism. What I'd like to add is that there is something that we're now sensing, is that we're speaking in universal terms, but we've not yet integrated the regional dimension of judicial functioning. And I was in Cameroon not too long ago and with African delegates, and it was quite interesting that when they start to speak about the ICC, there is this outright about saying that, the ICC in The Hague is not our court. We need to have our own court. And I think it's not really saying that this court is not good, but it's an issue of regional identity. And maybe that's the next stage of the development of judicial mechanism, is that should we establish all these mechanisms at the universal level, or should we also have a better sort of sharing of responsibilities at the regional level, whatever is a region, because that's going to be another issue. And then why not having deference, mutual supportiveness, and so on? We have had that at the universal level, where at the European level with the European Court of Human Rights and the Court of Luxembourg, why not also sort of thinking in those terms for other courts and tribunals? But I think that we can't say that judicial settlement is not accepted. It's maybe the functioning, it may be there is need for refinement, and maybe also there is need for resources for this.
No doubt. I think it's time maybe to see whether someone would like to add. Pierre, maybe you have an opinion. No, but you said that you had an opinion on everything that was discussed during this conference. So I thought that... No, but you have to stick to your reputation, So, okay, so... Take the mic.
Oh, how embarrassing, Hélène. So I need to,
no, you're in-house.
You invited me, so I'm trying to be. Well, thank you for giving me the floor. I should hide. How to start? Of course, I'm going to speak about an institution I served and to which all of us are somehow very much attached. But to come back to the issue of the ICJ being the principal judicial organ of the UN, which has, I think, it is very important to see it as such. There is and it's probably best expressed through the advisory proceedings. Somehow the court is the top legal advisor of the General Assembly, of the Security Council, through advisory proceedings. There is an issue when we speak about courts, it's independence, of course, of the body. The court is the creation of states, and there are two issues that I think the fact that the judges we spoke about, you referred to the elections that took place recently, the fact that the judges may be re-elected under the statute itself, the judges of the ICJ may be re-elected. Other courts' judges may not be re-elected. Of course, this is a way for states to exercise control over the court. It is in the statute, and it is the will of states. What is strange, somehow, is that the court itself, when it changed its rules in 1978, before the rules, under the old rules of the court, the judges were always free to issue individual opinions or dissenting opinions, but the vote in the operative part was anonymous. It was 10-2, and you would not have the list of names who would vote for that point or who would vote for another point. And you said this morning that Kackenberg refused in the Upper Silesia court that the judgments, that the names of the judges would be identified, that the result of the finding would be linked to the identity of certain judges. The court itself in 1978 changed that. And I've always wondered why they decided to identify themselves in the operative part, because I think it exposes them individually. And when we are working in a court where judges may be re-elected or not, the outcome of the judgments or the advisory opinions, therefore, states, the masters of the court, will be in a position to identify very precisely who is the good guy that voted for us, who's the bad guy that did not vote for us. And I think somehow it increases the dependence of the court vis-à-vis the political master. And I've never understood why the judges themselves put themselves in because they choose the rules. They change the rules by themselves. And also, I think there's a lot of many scholars have said that advisory proceedings are a great way for the court to develop international law. Maybe it's more ambiguous in such a setting, because those questions raised by the General Assembly are highly political. Kosovo, the war, nuclear weapons, no Mauritius, etc., etc. Very political questions. The border between Burkina Faso and Mali, you pick 5 good professionals, they can do that. But those very difficult legal issues, of course, such a court will always somehow come with an outcome that the states can live with. And I wonder if international law is really developed through advisory proceedings in such a setting where judges are so controlled by the General Assembly when elections come. And it's a good thing that the court is in The Hague, but still The Hague is so close to New York.
When it's about election, at least, yes, probably. But I would be happy also to add to Mamadou Ebié, if you would like to give his opinion on this, because Laurence just suggested.
I think on Laurence's point, I think that there is also a certain skepticism about international justice that we shouldn't hide. It has been coming from different forums. We have seen it with respect to African countries and the ICC, but we have also seen it with respect to international investment tribunals. And the question whether the initial idea of internationalizing a dispute between states and individuals is altogether a good idea. When we look at it in the Versailles Peace Treaty, they try to specify the areas where it would happen. Later, they introduced the exhaustion of local remedies so that to limit the number of cases that will be always coming to the international forum. So I think that there is a question that we will have to face in this generation, which will relate first to whether we shouldn't regionalize more international dispute settlement and whether we shouldn't nationalize more certain type of disputes that have reached the international level. Of course, I phrased it without giving too much of my views, but...
Christian Tams will complete what you said or oppose what you said.
Well, I think I'm picking up on one of the points that you made, Mamadou, but I think if I'm taking the sort of the big question of the panel, how does this dispute settlement system that we've been discussing look from a contemporary perspective? And I think it looks, my thoughts are in 3 points, which I'll just simply throw out, maybe to continue the discussion among panelists or members of the audience. So I think one is it looks surprisingly diverse. Okay, we always gravitate towards the ICJ or PCIJ, World Court, the Court, etc. But I think one of the engaging points of this morning's discussion was that there's so much beyond that. And that is hybrid tribunals in their dozens of the sort that they were introduced, sort of mixed arbitral tribunals, let's say bizarre curiosities like the Silesian special cases, sort of strange, not really sort of world courts, but perhaps yield the more interesting stories. And then ambitious attempts that never really went anywhere, like internationalized criminal tribunals or attempts at hybridization of criminal proceedings in the interest of a broader international community interest, which took time to come to fruit but were in some ways there in the 20s. So I think surprisingly diverse. I think my second point would be it's useful but marginal, or marginal but useful, depending on how you want to emphasize. So I think I've probably overemphasized my point about the marginal relevance only of the World Court. So I don't need to sort of go into that again, but I do think from a dispute settlement perspective, or if you ask sort of what were the grand questions of international law in the 20s, none of them really were litigated, or for few of them, I think people thought courts were the solution. For niche aspects, yes. For useful outsourcing or delegation of decision making, yes. But I'm just sort of picking up on points that were made. Disarmament, sort of your point, sort of massive treaty making, collective security, massive institutionalization or separate treaty making, alliances versus power politics versus new world order versus old system. Courts didn't play a role had a lesser role in those matters. So I think on the grand issues, their role was limited, but of course it was useful, where they were sort of used or tailor-made for particular issues. And then I think the final point I would make, my third point, is a convenient tool, and maybe this is really sort of where the 20s were the first time where this was applied with some level of sort of frequency or regularity, a useful tool for, either setting up systems for impartial decision-making or for institutionalizing, peace through law or world order or hegemony through law. And I'm using it in a particular open way. I think this instrumentalist idea of using courts to continue, to apply the law whether we like it or not. I think that is something that we see on display in the 20s as well. People spoke about the sort of the biases of those commissions or the problems of that commission. And I think we see that today. You mentioned sort of reservations about international criminal justice. We have not really talked about investment arbitration other than saying how it's sort of perhaps a continuation of mixed arbitral tribunals. But of course, it's also a system of arbitration that if you ask any audience that is not us, you get a 90% vote that it's sort of something bad. Not because, the idea that we have too few courts in international law is nice and fine, but where we have relatively many courts and tribunals that function relatively effectively is not necessarily something that wins you sort of applause. And I think we see elements of that also in the 20s, where you have sort of great reservations about courts that are tied to settlements that were perceived as unjust, courts that were set up under modalities that were perceived to be biased and not impartial. And I think that's a discussion which we've blocked out so far, but which is very live today. And I think we see that too in the 1920s, at least sort of early aspects of that. So those would be my 3 points. I've spoken at such length that I'm not even sure what my 3 points were, but sort of marginal and useful was one, diverse and politically tainted at times. I think those were my 3 bigger points. Thank you.
Reaction from the panel, and then...
I'd like to come back to what Pierre has said about the advisory function of the International Court of Justice, which was also a function for the Permanent Court of International Justice. And I will disagree with what Pierre has said. I think that what we've seen with advisory opinions, and in fact it was much more liberal at the time of the Permanent Court of International Justice, because non-state actors were able to ask for advisory opinions to the Permanent Court of International Justice. But what we've seen is that, in a way, from constitutional issues, the International Court of Justice has moved to global interest issues. And I remember vividly the proceedings in relation to the legality of the resort to nuclear weapons. And this was the first time that you had such a request. And I remember, you had about 35 member states of the United Nations participating to the written proceedings. You had about more than 30 states appearing before the International Court of Justice, making statements about nuclear weapons and so on. I think, and for me, it showed that we needed a place where all these legal issues arguments could be confronted. I think what we've seen with the request about the wall in the occupied territories in Palestine is also very revealing. A lot of participants, non-state actors behind the scene and so on. What we've seen also with the request about Kosovo is about the same. So, and what we may see with the Chacos request is going to be interesting. So what I would say is that the advisory function is important. And in a way, we should not be afraid of the politicization of all these issues, because that's what it is about. And this also brings me to maybe something that we didn't stress enough, is that when our grandfathers, because there were not many grandmothers at that time in the 20s, built the League of Nations, there were about 30, okay? They were mostly white, okay? And today, the world is much more diverse, 193 member states of the United Nations and entities which are called states which are outside of the United Nations. The world is diverse in many respects, and I think that this may be something that we've not yet taken enough account of, is the diversity, and how the diversity should be reflected in global justice.
Yes, just maybe 1 or 2 remarks to Christian. What we have seen in the developments after, especially after the Second World War, is that because in the interwar, let's not forget, we had the big discussion, and Lauterpacht was in it, in the function of law and others, on justiciability. And the League, the Covenant, of course, didn't ignore peaceful settlement. So it had this 12, 13, 14, the articles, where it was arbitration or resort to the council plus 3-month cooling period. Parallelly, and we tend to forget this, states in the interwar period concluded over 300 bilateral treaties, state-to-state treaties of dispute settlement, inclusive of many procedures. They were usually treaties of conciliation, arbitration, and judicial settlement. A question is why they were never applied, but they did. It was and it was a way of addressing all sorts of issues, maybe the more vital ones through conciliation or arbitration, and maybe leaving the more judicial ones for the new permanent court and then the court. Today, what do we see? Areas of non-justiciability before have been greatly reduced through this assumption of treaty obligations. So I don't think that's a bad thing. I mean, already it shows that, of course, there is politics or big, high questions, but a lot of things, a lot of areas have been covered. And the fact, for example, that the environment is now coming, not directly but indirectly, to this court, might show some things. You know, it's something that environment was always something different and somewhere else, but you know, now we're starting to get that thing. So that's why I tended from the beginning to think that we need to see this continuity and discontinuity, and to see that always, you know, states, and even those who wrote about what states do, develop these theories in the interwar period to adjust, you know, with a realistic way, to adjust idealism that was maybe rampant at the time to more realistic attitudes. So that's what I wanted.
No, just the exchange regarding advisory opinions was interesting. You have two views on this. Obviously, these are political debates which cannot be held elsewhere, which are brought to the court. The problem is, can the court resist to these debates? And so that these debates are healthy for the international society or community is one thing. Whether the court can resist these debates is another thing. The nuclear weapons in 1996, at the time when you had also elections at the court, showed perfectly the tensions which can take place. And we could see the same tensions for the Marshall Island case, which was a case and not a advisory opinion, but nevertheless, we had this very same tensions arising. So can the court resist, or what are the conditions for the court to resist and be able to offer this alternative forum that it becomes? This would be a question. I see Pierre would like to speak, but Patricia Clavin also asked for the floor. So Pierre will have to wait a few minutes because... Patricia, please.
Thank you. Sorry, Pierre. It follows on a little bit from what Christian said, but in fact, Laurence anticipated it really, which is that from a historian's perspective, listening to you, what the thing that really came home to me in the last 2 days is that what law also enables you to track is the changing nature of the international and the changing nature of what people understand peace to be, which is something that is the other side of what we've been talking about, really. So when, you know, in 1919, you have the shift from empires to different types of state structures, sort of colonial overhangs, mandates, free cities, quite a lot of these structures have gone. So the international has changed. The focus then was on trade. It was much less on the regulation of capital. Capital emerges later. So it's also from when historians read your work and read the law, that's the other side of what comes out and where the threats to peace are seen to come from. So, you know, the threat of peace was seen to be militarism, and that you needed to effect that through disarmament. Now we understand the threats to peace to come from somewhere else. Sometimes I'm slightly worried we've forgotten about the weapons, but it's just to sort of flag that up, really, because that's what makes your work so interesting for people in my field. Thank you.
Maybe a short remark from the private law side. What seems me to be remarkable is a development in the 1920s where people started with a belief you can solve problems by law, peace through law. And there was a great deception in this respect in the 1920s. Maybe just to go back in a domestic setting, there is was a famous development within Germany with private law. They had a new code from 1900. They thought everything had been settled. Then the war broke out. Then they had all the changed circumstances which had not been foreseen in the civil court. And there was a famous judgment of the former Reichsgericht in 1922, 1923, when we had hyperinflation. And you could not simply tell your creditor, I pay you 1,000 Reichsmark and you give me back what and I give you back what you gave to me. And the Reichsgericht came up and said, now we have to do it differently. We have to step away from the law. We have to find a good solution. When I look at the reparation issue, maybe it's a little bit similar. Maybe it's oversimplification. But again, they started in a very legalistic way. And they ended up in negotiating and coming up with solutions. There were still some areas where the law worked quite well. The MIT, for me, is a good example. But what happened in the 1930s? They were simply given up because there was a kind of mistrust in these easy legal solutions. And this is maybe something we should also see as jurists, that we have limited means. But on the other hand, what you said about the role and function of the International Court of Justice to be involved also in a larger political debate, maybe this is also a function which is up to courts, and this is something we have a lot discussed, let's say, starting with the 1980s. We talked about the past and the role of courts and criminal justice in this respect. Maybe we are standing today also a little bit more far away from the illusions of the 1920s.
Idealism, let's say.
Yeah.
I don't know if there were illusions, but there were idealism for sure. So, yes, sure. Pierre?
Hélène, you're too kind. But if you give me the opportunity to somehow express myself better, I was maybe taken by surprise by your first request for questions. And I did indeed express myself not fully on that. But I'm not saying that the advisory proceedings do not help to develop international law to a certain extent. I'm just saying that in a system where the judges are susceptible to be re-elected, in a system where the judges today are identified specifically on the various points of the operative part, if deeply dividing or difficult political legal questions are put through the advisory proceedings to the court, the member states will like to see the court coming out with an answer that they can live with. And that's the only thing I wanted to say. I'm not saying that those proceedings are not important, that those proceedings do not contribute to the development of international law. I'm just saying that somehow it is no surprise that because those type of questions are put to the court, the composition of the bench, we have seen it, the composition of the bench has changed over time. It was, 30, 40 years ago, the bench was made of scholars most of the time. And we've seen the composition of the bench changing by former legal advisors, etc., which is not a bad thing as such, but it shows that the member states, when they elect judges, I think they want the court to come up in those advisory proceedings where big questions are posed to the court with outcomes that they can live with, which is great to see for us because it means somehow that the court is taken seriously, despite the fact that the advisory proceedings are only advisory and non-binding. Member states pay such an attention to the outcome that they want to control somehow the outcome by electing to the court people that understand the member states themselves. That's all I wanted to say. Sorry.
I would like to do two things. First of all, to come back to the Versailles Treaty, and secondly, to respond or to give some comments on Burkhard Hess' comments. I think that there are two things, and which are relevant in the Versailles Treaty. There is, first of all, I would say the individual justice, and when we speak about the ICJ, the Permanent Court, when we speak about the Tribunal Arbitral Mixed, it's all individual justice. But there is in the Versailles Treaty something which I would say global justice, the payment of a lump sum as a global compensation for whatever to a state. And I guess I am not saying that the first thing is not important. No, it is. Of course, it's really individual justice is very important on all levels. But on the other hand, I guess that the Versailles Treaty made clear that in some situations after war, because that's what we speak about in the Versailles Treaty, you cannot have individual justice, but you just have a lump sum justice. And I guess that idea has then also been transmitted through over the generations. And it is now the basis of the mass claims which exist, mass claims proceedings which exist today. And for me, there is a big difference between individual justice and what I would say micro justice on one side and micro justice on the other side. And if I just may give an anecdote, and I will shut up, when we started with the Bosnian Claims Commission. Now there was a big conference, and people from the human rights corners came and said it's absolutely a shame that this commission is deciding property rights, because property rights, article blah blah of the Convention on Human Rights, and so on and so on. It's very important, and you have to hear the parties and so on. And then at the time I had a Palm Pilot, no longer exists anymore, and I made a small calculation. I said, okay, fine. If you assume that we will sit in Sarajevo from Monday till Friday evening, if you assume that we will take no holidays, if you assume that we will take 1 hour for each case to allow people to explain their thing and to render a decision, I can assure you, if you're in Bosnia and you listen what happened to all those farmers who were chased off their house, ethical cleansing, half an hour will not be sufficient. But anyway, let's assume that you take 1 hour to make a decision, hear parties, make a decision, render it. If on those conditions we will follow your proposal to have individual cases, then we will need 250 years to settle this thing. And I guess this is a very important thing. The global justice vis-à-vis the rough justice, the surgery on the battlefield, I would say, which is not the most sophisticated art of medicine on one hand, and the individual justice on the other hand. That's what I want to say.
Yeah, maybe coming back to some of the issues that were discussed and maybe going in other realms than the International Court of Justice. So Photini mentioned the issue of environmental governance and the issue of dispute settlement. What is interesting is that, yes, you have a few cases which go before the International Court of Justice, but they're rather marginal in their scale and the scope. But let's think about what happened with the climate change regime. In the Kyoto Protocol, it was quite interesting that states were able to put in place a system which was quasi-judicial in its way of handling breaches to the Kyoto Protocol. Now, when they negotiated the Paris Agreement, one condition would be to get rid of all these dispute settlement mechanisms, okay? And so for the time being, we're left with the Paris Agreement on climate change, and it's going to be one of the major issues of the 21st century. We're left with transparency, reporting, investigation, but nothing. And the only sanction that we have is the sanction of the public opinion, because transparency is there. So I think that we should also take into account that, yes, maybe that we've accepted more third-party judicial settlement, but there are also a lot of issues where we don't want them. And so that's one thing. Now, to speak from the periphery, I'm not living in The Hague, I'm not living in New York, but I was thinking of the new judicial mechanisms that have been put in place. And when you look at the disputes which are brought before these dispute settlements mechanisms, you realize that they are much more important in economic size than what is brought before the court. I'm thinking of the World Trade Organization appellate body, the panels and the appellate body. And there I think that it was, and I would be happy to hear Hélène on this, but it has only 20 years, so it's very young, okay? But it worked quite well. It worked quite well, and there was some credibility, some predictability, and so on. And there is, I think, a major assault on this mechanism currently. So that is something that we should be very careful about thinking that everything can last forever. Now, there is also another judicial mechanism, and we have a judge of this institution in this room, which has not been mentioned, which is a very recent one. It's the Law of the Sea Tribunal. And in fact, when you look at the disputes which are brought in the context of the laws of the Sea Convention, in their size, they're quite important, because it's going to be about delimitations, it's going to be about natural resources, and it's going to be about a lot of issues for the well-being of the people which are concerned. So we should also be looking at these institutions and maybe wonder why we don't speak more about them.
Lisbeth? I think you have maybe to.
Can I make a comment?
Yes, of course, and then.
I mean, to add to what Hélène was thinking, when you see the whole the dispute settlement of the law of the sea as a whole, it's actually, it really resembles what precursors had thought about putting many dispute mechanisms together, and a permanent one, and arbitration, and other conciliation, and it could be obligatory, and so you have a palette of mechanisms within one dispute settlement system. That's one. The second one that the second point that I wanted to make after listening and what you've been saying as well about is this return that we notice, and with what Laurence also has been saying, I think we've noticed a return towards interstate. I mean, there were years where we were all focused on what individuals are doing in human rights and in courts, etc. And now we see, for example, this return of interstate arbitration within the permanent court. Who would have thought? Not the new mechanisms, this individual with or company with state, but state to state. And here also, where there are big stakes involved, return to arbitration within the law of the sea or the tribunal. And return of the state in investment arbitration, where you have some state-to-state now cases on interpretation and application of the investment treaties. So that's another aspect that I think we should add to the individual justice.
Maybe, is it on? Yeah. Maybe just, I don't want to be parochial, because obviously I'm likely to be parochial on the Law of the Sea Tribunal. But I think it is very interesting that there are more and more sectoral mechanisms. Now, perhaps not for all relevant sectors. There is, to the best of my knowledge, not a particular specific environmental law type of dispute settlement mechanism, so that issues like that would go to the International Court of Justice if they eventually reach the stage of going for formal dispute settlement. That system, that picture of, and in fact the more the underlying consideration as to do we benefit from a very general system, which is essentially what the BCIJ starts out with, which is what the ICJ does, and provided you've got everything organized at the level of admissibility and jurisdiction, then we still have good examples of very general jurisdictions, but by and large, more specialized jurisdictions have arisen. I think first in the field of human rights law, and gradually others. Perhaps international criminal law is really a specialist area because it deals with individuals and individual criminal responsibility. But other than that, the picture, I think, is very fragmented. You have one major general body, and then for some areas you have specialist bodies, but not for all areas. Now, as to the dispute settlement system under the Law of the Sea Convention, I always find it intriguing that I have to push the point with my students that this is compulsory dispute settlement. It looks like, oh, you have a multitude of options and you can pick an option, and maybe you don't pick an option, but then the good news is you'd still be in the dispute settlement system. I think that going through the drafting history, one of my predecessors as a Netherlands legal advisor had a hand in that. This is the so-called Montreux Compromis that led to the whole dispute settlement structure in the Law of the Sea Convention. But apart from that, it is an interesting system in the sense that it is compulsory, but it also brings a certain amount of flexibility. You may choose arbitration, you can still go to the International Court of Justice or go to the specialist tribunal. I would say that I've found out that all my colleagues in Hamburg are not very happy about the arbitration because it means that really good cases go somewhere else and don't stay in Hamburg. At the same time, some of the judges participate in those arbitrations, so it's probably not much of an issue. There is another issue, though, but I think that tags on to something that Photini has said. I'm not sure if we're really back to specifically interstate dispute settlement. With respect to the Law of the Sea Tribunal, I would say that specifically in the prompt release cases, the formula of bringing a case, the case brought by the flag state or on behalf of the flag state, that has given the possibility for many ship owners to act, and it's not. This is not legally speaking, because they all bring. I'm not sure what it's called, a plein pouvoir, credentials, something like that. They're representing the flag state, but in actual fact, they are representing the ship owner. Now, I think that in itself has been very useful in the sense that the prompt release mechanism has been used. I'm not saying extensively, but it has good use has been made of it. And so in an early stage, case law on prompt release was really clarified. But I recently had an interesting discussion with a young researcher, and it was about human rights claims before the Law of the Sea Tribunal. And I thought, the Law of the Sea people had been looking at situations of potential human rights abuses at sea before the court in Strasbourg. So we're all thinking Medvedev, etc. But the interesting thing is whether developments such as prompt release cases being brought on behalf of the flag state by a counsel who has most likely been hired by the owner of the ship, whether that mechanism in itself, as many benefits as there are in a mechanism like that, whether that mechanism in itself is not sort of creating a very implicit impediment to raising human rights aspects of ships that are arrested and the duration of arrest and the reasonable bond stuff, etc. So this goes to questions of the implicit effects of how the flag state is represented and how a relatively flexible system, in the sense of others may be mandated to represent the flag state, what exactly the consequences are of that. I'm not sure that that is something that has been really thought through, but it may be something that ends up on the agenda later on. Thank you.
Yes, it might be, but in fact, representation of states in courts has not been deeply thought so far. And when the issue arose at the WTO of representation by private lawyers, there were really two schools of thought about that. Those who were, as a matter of principle, opposed to this, and those who thought, okay, I mean, let's consider that legally speaking, they are representative of the state, and the rest is behind closed doors. And so, but it opens up to many other considerations when we see that one of the debates nowadays is also third-party funding, which is not only for claimants, and it's not only in investment, it's in investment, but not only. But it's about claimants, but it can also be about respondent, and therefore it's all about who lobbies and who promised to pay in order to have states being in position either of responding or carrying a claim. It can depend on the systems. So yeah, we have many stakes which maybe were not perceived in the 20s, and indeed it's difficult to assess these stakes, account taken the diversity of international courts and tribunals and dispute settlement system, as underlined by Christian. There I fully agree. But one question that I would like to ask to all the speakers, maybe of the conference and other people, in a way or another, we are facing a legacy of the 20s. But in your view, what was there something missing that we have now? And on the reverse, is there something that we have forgotten from the 20s and which could explain where we stand now? I mean, if you were to revive something from this period, what would this be, which is maybe missing in our current landscape? And
sorry. I like it. I think that when I see all those pictures of the 1920s, there is a big difference technologically, procedurally, with how things are done nowadays. I guess that the professionalism in arguing cases has been incredibly increased since the 20s. But maybe the essence is the same, but I probably the pleadings are much longer, much complicated, much more witnesses, much more statements, much more documents, and so on. No, much more costly.
Much more bureaucracy. Pierre, it's you. No, much more bureaucracy leading to maybe boredom, but no, I wouldn't be bored. One thing that changed, of course, right, the charter use of force. One thing that changed after. So that's one thing. I don't know to what extent it has changed the way we view dispute settlement, but you know, it was that was the big change for me. If you go through the this time period and look at it in the series of events, so that would be one change, which is fundamental from the before and after. And your second question was something. I had something, but I forgot it.
Was there something missing that we have now?
Something
Maybe
missing that
you should explain what it was.
I had it, but I forgot it.
It's one of the main differences. And so,
I don't remember.
I think what I can take from the conference, from what I learned a lot, is at the end of the 19th century, in the beginning of the 20th century, the states, because it was mostly states, but also private individuals behind the states. And I don't think we spoke enough about the NGOs who were there for the creation of the International Labour Organization and for other mechanisms. But this put aside, what was interesting is that there was a belief in plurality, okay? And remember, we've discussed so many different systems. We had with Guy Sinclair a presentation of the International Labour Organization. Can you realize that early on in 1926, the state accepted that we would have investigations, on-site investigations in countries to check if the labor conventions would be respected. So that was one thing. Then this morning we had a presentation about the special tribunal in Upper Silesia. This was just incredible. Then we didn't speak much about arbitration, but arbitration was also very important. We didn't speak much about the Permanent Court of Arbitration, but it was there already, and it was showing its effects. We also spoke we spoke about the mandates, we spoke about minorities. Each time there were accountability mechanisms of different types. Were they efficient? That's another issue. But what is interesting is that there was this belief that there should be accountability of different types at the international level. And this is maybe something that we should go back to when we look at this period, is that they were not afraid of plurality. They were not afraid of diversity. And in fact, they were speaking about it. And today, and maybe I'm a bit too obsessed about this, but there's all these things about chaos, about unorganized work, and so on. No, we have more of these mechanisms, but we also have other tools for organizing the interplay between these mechanisms. So that is something that I would like to take from this period. Now, I think also, maybe I'm too realistic, but in the early 20s, there was a belief in the role of law, and that has been stressed by a lot of people, that law could play a role. And Photini has also mentioned all these treaties which were negotiated in the 20s, 30s, even in the 40s and 50s, okay, where states committed to arbitration, committed to go before the International Court of Justice, and so on. And I would say that today, we are much more suspicious. We like law, we want to believe in the rule of law, but we're also very suspicious. And maybe we should go back to idealism, and maybe that is something that we're missing today.
Yeah, but if you look at the yearbook of the ICG, you could see that there are 272 treaties, including a compromissory clause calling for the court in a way or another. But this list has not moved for more than a decade now, which means that states do not include any more compromissory clauses in their treaties. Or else we speak about this new generation of treaties, the regional trade agreements, and this new generation of dispute settlement system, which were at stake stake in the international debate for other reasons. But we have this. But at the same time, during these years, there were failures as well. I mean, Professor Callahan mentioned the court on terrorism, and this attempt didn't work. So maybe there are things to be done from this experience. I don't know if you would like to say a word about this. With the mic.
Well, I guess I hesitate to sort of compare what is better or worse from a system from the League to the
No, it's
to
provocative.
the UN.
It's provocative.
Right. Well,
So,
yes.
but,
But I guess the one thing that I would always keep in mind when trying to think about legacies from the League to the UN is that one of the biggest differences, whether it's good or bad, we can debate, but giving the permanent members the veto power changed the politics of how the Supreme Council versus the Security Council work. The reason for giving the veto power was because the Soviets got kicked out of the League of Nations in 1939 and did not want to come back into another organization where they could get kicked out or outvoted. And so what the veto power now does is it kind of it traps the Security Council in a kind of suspended animation of where it was at the end of the Second World War, and can always veto anything a great power doesn't want. The only option in the League was if a great power was unhappy, they either had to quit or find a way to compromise.
now you have the mic, Guy. So you have to say a word about ILO, because I mean it's intriguing, you know. Views from now, it looks so modern. Tripartism was so modern. There's investigative procedures, which are not dispute settlement as such, but nevertheless, and you have written that it was about transforming the world. So you need to say something.
This is a pass the parcel situation. If you get caught with the mic, then you have to say something when the music stops you. Yeah, so maybe just a couple of thoughts. Firstly, on the ILO, there was a moment sort of at some point I think in World War II, well, actually Patricia would know much better than me off the top of my head, that allow me to know that the ILO was seen as a model by international lawyers and sort of people thinking about international politics. David Mitrany, the founding father of functionalism, sort of praised this idea of tripartism as representing the true a mechanism of functionalism, and it was seen as a possible model for the organizations to come to deal with these sorts of social and economic issues after World War II, but it never worked out for a variety of sort of strange reasons. I think who happened to be the director at the time and the different interplay of states at the time. But maybe it's a time to start thinking about that sort of representation of particular interests, although it does then lead again to sort of more slicing up our issues into very narrow functional areas. So that was one thought. The second thought was I was just thinking about Laurence's point about accountability. There were all these different accountability measures, and maybe what was missing at that time that we have now, or that we're thinking about now, is accountability of these international organizations, right? Those are accountability mechanisms for states. And now the pendulum has swung, or it's become reflexive or something. Now we're thinking how to hold these international organizations to account, and maybe that's worth some investigation. Maybe there were some early thoughts about that. Of course, there were things like the advisory opinions about the ILO were concerned with ultra vires actions, but beyond that, what about questions of responsibility and so on? It may be worth going back and having a look for early discussions of that issue. Nobody wants to take the mic from me now.
No, it's not a systematic trap, and so Yes, please.
I only have a minor point by way of an addendum to Professor Callahan's point about the League Council. And forgive me if this was mentioned at some other point in our proceedings, but I don't think it has been. States parties to disputes, if the disputes were brought to the Council, didn't vote. So it was conscious. It was more like a judicial function, or at least that there was some consciousness in the way that. It's supposed to be the same in the Charter. It's supposed to be, right? But yeah. Anyway, just small. Just a minute. Right. Yeah. Anyway.
Maybe if I could say something about, and then Mamadou will. No, I don't know. About the ILO, because it's something, you know, when you teach international organizations, you go back to the constitutive instruments and you look at the provisions and then you speak with people working in these organizations. It's quite interesting. I think it's Article 33 of the ILO Constitution, which is providing for the resolution of disputes relative to the interpretation of the ILO before the Permanent Court of International Justice. So it's a very special dispute settlement procedure whereby the organization can ask for an advisory opinion, which is going to be binding upon the organization. And I remember that, you know, twice in the life of the ILO, there were discussions about why not the ILO asking for an advisory opinion to the court in this context with respect to the situation in Myanmar, not for the Rohingyas, but before, when there was forced labor, and then a few years ago when there was a blocking of the employers about the freedom of expression and the right to strike and so on, and there was no possibility of doing anything within the organization. So what I think is interesting is that in the 20s, they believed that the Permanent Court of International Justice could help an international organization to resolve its internal problems. And today, we don't have so many signs.
Sure, and when you remember the Libyan case in the 90s, you could see that the International Court of Justice didn't want to help the Security Council to solve any issue. So that was clear for reasons we have already evoked. So I was going to ask you, so please, Nathaniel Berman.
I wanted to pick up on a couple of things that have been mentioned, partly harking back to Jennifer's talk earlier this afternoon and some of the comments about the ILO and also Burkhard's comments, and also to my talk. For me, I think that if we take a broader perspective about the effect of the Versailles Treaty or of international law generally on disputes, to my mind, as I tried to say on Wednesday, one of its major roles, or maybe for me one of the major roles, is not so much the settlement of disputes as the framing of disputes, so the way people understand their disputes, how they come to the table, how they frame their claims, whatever happens to those disputes afterwards, and the incredible creative effect of the Versailles Treaty in having people understand themselves in new ways as national states, as minorities, and so forth, people struggling for self-determination. And every moment where international law had a big effect on the international stage writ large, it's been those moments when it's allowed people to think of themselves in new ways. Think of the anti-colonial struggles of the 50s and 60s, where people thought of themselves, framed their struggles as, we are fighting for self-determination as a right of international law, and the world was transformed, for better or for worse. It was completely transformed with this new framing. And in the field of indigenous peoples' rights, the effect of what is shockingly a new category of indigenous people's rights in international law, the effect this has on indigenous people's struggles around the world has been huge. Just a reframing, a language, a vocabulary in which to talk about it, in which to present claims. My sense here, as we're nearing the end, right, is I keep on wanting to fight off this feeling that we're reshuffling the deck chairs in the Titanic, to use that cliche, that we really live in an era where international law is under assault in terms of being part of public discourse. Forget about settling disputes. Whether it's part of the public discourse of the framing of the most important disputes around the world. Now, I happen to come from a country which is currently undergoing a massive assault on law generally, let alone international law. I mean, certainly international law, rule of law generally. Russia is another major power which seems to have nothing but contempt for international law. The Brexit campaign seemed to be an assault on the notion of weaving countries together through law. The question, I think, for everyone in this room, who's basically almost everyone in this room is a legal professional in one way or another, the real question, I think, for us is how to capture the imagination of the world. Not so much in terms of techniques and technicalities, but what is the profession doing today to reignite the popular imagination around the notion that there is a way, that there is an international discourse framed by, we could call it legal categories, framed by certain kinds of consensually accepted categories around which people can understand their disputes. And if we can't do that, if that consciousness around the world is declining, then all the technical discussions of the institutions and how it's working are it becomes really quite marginal. And what we don't want to be doing is be to somebody to look at us in this room to say, these are people that are living in the 1930s. The ship is sailing off the cliff, right? And they're still sitting there in Geneva talking about the bureaucratic rearrangement of the League of Nations. Where is the imagination? The new categories of helping people reframe their understandings, right? NGOs is one way, but it's also somewhat in decline. Is there some way to re-involve people in the world in understanding themselves as part of an international community? And I think Versailles Treaty did that for a while. And that, for me, the importance of the mixed arbitral tribunals isn't so much the detail of the procedure and how it worked out and whether things were paid or not, is that people went to them, right? The fact that people even went to them is amazing, that they understood that this was a way of understanding their disputes. And I think that in terms of what's lacking today, it's us to try to ignite international imagination of people in the international world, real people, and how to understand themselves in this new way. And I say one way in which I've seen it because of recent work that I've been doing is around indigenous people's rights. It's a category, it's barely, it's only a UN resolution. There's not even a treaty on it, shamefully. And yet it's ignited indigenous people's struggles in a whole new way. And what else can we come up with? That's what we should be doing. That's my manifesto.
Which is an incredibly idealistic discourse at the same time, because you imagine law as a common language, or having the qualities to carry. Yeah.
It has been at some time.
Mm-hmm. And so you... So in a way, you join what Christian said this morning, courts as agent of the legal order at the same time, and their ability to help formulate common ideas. I don't know. Mamadou and then Jennifer.
Okay, I have 3 points. In general, I'm very idealistic and very measured in my criticism, but I think today I will just do something different. Perhaps one thing that shows continuity between the dispute settlement system under Versailles and the one that we have is that we are still not yet at the level of an adequate or proper gender and cultural representativeness in the system. I'm very happy to see that the panel today is more balanced than usual. But still, when you look at the composition of international tribunals and courts, there is still something that could be done and that could help us go beyond the Versailles system. The second point that I would like to raise relates to the fact that put in a very neutral manner, you will say that any system defends certain interests, and that the system of Versailles, I showed it through the mandate system, also was there to defend certain interests. Nowadays, the system does defend better certain interests than others. I was very disturbed when I saw that Germany was opposing the introduction of an arbitral clause in the transatlantic trade and investment partnership, because African countries, this question was never raised. When they said, okay, your judicial system is not developed enough, and therefore to ensure the protection of investment, then the best way to go about it is to establish international tribunals and court. But one could think about another system, because even the best developed judicial system do render very bad decisions. So why not focus on the cases where domestic system would have failed to provide remedies before lifting the case at the international level, than just to consider that certain type of countries are more fit to the system of adjudication than to be subject to adjudication than others. And there are other areas where when you look, you realize that the system protects better certain interests than other. And then one thing that is a complete change from what existed in Versailles is the right of self-determination. But I say this with a little bit of sadness, because self-determination came as a right of independence for all the colonial countries, with the idea that when they are independent, they will be able to better protect their own interest. And today, when I look at it coming from Burkina Faso, 50 years after our independence, I still realize that the system managed to maintain itself despite our independence. Of course, it's not to blame anyone, because I tend to believe that from the domestic perspective, we could do better in order to advocate for our interests and defend them. But self-determination has changed the fact that the mandate system, for instance, was imposed on these countries and people. But now that they are independent, they have accepted certain norms more or less willingly, and sometimes perhaps not knowing more the scope of the obligations they are involved to. So this is my cynical day, and I'll stop there.
This was more or less what you said. I had Jennifer, please. Jennifer, you should raise your hand because she doesn't.
Sorry. I was just trying to find something that I wanted to say, but I couldn't. So I wanted just to pick up on this, what we've been talking about as law as this kind of common language, and obviously, law is a common language and an important language. And I think that to me is what's been brought through, and I don't completely agree with the marginalisation of international criminal tribunals and international criminal justice and courts and commissions. I think they still play an extraordinarily important role, and I think we can, and it is because they are seen as justice mechanisms. And even though they might not be, the claims that are brought to them might not in fact be what the court wants to have brought to them. I think what's interesting is what is brought. So with the International Court of Justice, I think it's really interesting for us to see the kinds of claims that are brought there, even though they might not seem sometimes to fit the work of the court. What I'd be really interested to do, and years ago I had a conversation with the International Criminal Court, one of the personnel there, and he was telling me about all the different claims that are brought to the International Criminal Court, most of which are not taken up. And I think, that would be a really interesting project if it was at all possible to get hold of, all the different claims that are brought, because the bringing of these claims and the claiming of that space is something which I think we've created, and it's an important creation in terms of, there is a space where my claims can be heard, or at least I can make those claims to that body. They may not be heard, but there's that focal point, and that does, as was just mentioned, that yes, it does mean the creation of new identities, new means, and new ways of imagining themselves as part of this international community. I was always struck by the fact that one of the very first movement by the international community with Gaddafi in Libya was an indictment from the ICC. I thought that was quite telling, and so I think that we don't want to undersell these processes. I think there was a critical legal theorist, Mari Matsuda, who talked about the law might be unjust, but it's my right to claim it. And I think that's what we do, and that's why these are important, and they shift and change. And I think the comment that this plurality of accountability mechanisms, and we see them kind of reproducing in the past, but we see them reproducing in the present. We look at Bangladesh and its International Crimes Tribunal, Cambodia, and so on. I think we have kind of this diversity of mechanisms, but that are flawed. We know that, but that we can reshape them potentially through the types of claims made to them. So I think that was my contribution. I'm sorry, I've just had this jet lag fog all of a sudden. I was like looking at my computer, it's 1:40 in the morning or something. I should have.
Thank you very much. Have any question or remark? Any of you would like to or ask a question? Yeah.
Thank you. Yeah, maybe a question. Do you think that we will ever have another opportunity like Versailles?
It depends if... Do you include the circumstances which came just before? Yeah.
Sorry, that was a bit... No, I just think that the probability of having a peace treaty in this scale, a conference that changed so much for so much of the world because of the actors involved, because of colonialism, because of imperialism, it changed more than what 1945 did. And for me, that's the fascinating aspect of Versailles, and I think that's why we're talking about it over 3 days. Now, will we have the same opportunity in the future? Will this be available? And what do the panelists think? I mean, in these days of skepticism, of phenomena that were described by Professor Berman, and how law is being subverted by different ways of doing politics, and can we still imagine peace through law at this scale?
The short answer is I hope not, because Versailles came into being because the world was at shatters at that time. Maybe even more than after the Second World War, but anyway, that's a discussion. Secondly, at the time of Versailles, you had this idealism which started with the Hague conferences and conventions and so on. I'm afraid that now people are much more cynical. Third, I was always amazed by the fact that things were done in such an amateur way in the old days. People had an idea and they wrote it on paper rather clumsily, and then they worked it out. Now we are too technocratic to allow countries to sign something which they do not completely understand.
So, at Leon's question, my first reaction was to say knock on wood, because of course we don't know if you mean the before or the after. And I was thinking that historians used to usually say that there are two types of get-togethers or international conferences or what have you. Those that are held after war to prepare for peace, and those that are held during peacetime and sometimes lead to war. So it depends on how you view the Versailles Treaty. I'm not sure I'm not sure. I think this conference was stimulating. I have my ideas, but I won't say them. But so it depends on how you view the treaty, and that could give you an answer of whether it could happen before. Again, I mean, but you know, the first reaction is, hey, let's not do it. But the second one is that maybe movements like peace through law, which were really, you know, was before. Professor Hans van Houtte was saying, it was before the technocrats, you know, it was movements, peoples, groups, pacifists, religious groups, whatever they were, coming out and asking for something, and then lawyers putting it into some sort of form. Maybe now we're too technocratic or too bureaucratic, you know, now you'll have to go through and make a petition to the UN and, you know, see if a conference can be organized and whatever, so it might be difficult.
Thank you. 2 points. The first one is to come back to what Nathaniel has said about the situation, the current situation. What I think, and I'm not someone too optimistic, but I think that the institutions that were built over the 20th century, and surely the United Nations institutions have shown signs of resilience. And I'm thinking about the crisis in 2003 with the aggression of the US against Iraq and the words that were very strong used by the United States at that time and so on. And I think the organization, and thanks to Kofi Annan and others, has resisted and has been resilient. So what my hope is that because of what's going on, the institutions that we've built are going to be sufficiently resistant to what is going on. And we didn't speak enough about what is going on at the WTO these days, but I think there is the consensus, and because of the consensus, the United States are blocking the appointment of members of the appellate body, okay? And this is a dangerous path, and we are all quite concerned about that. But it doesn't mean that the institution as itself is not going to be able to resist to that. And I think that they will find a way to face this situation of blocking by the United States. So I would have some confidence in the institutions. It doesn't mean that they can resolve all the issues, but I do believe that in the course of the 20th century, we've been able to strengthen them. Now, the weak point, and this is in line with what has been said, is that we also have to adjust the powers of the permanent members at the United Nations and in other organizations. And in a way, what happened in November with respect to the elections at the International Court of Justice has shown that you have a very large number of countries who don't want anymore to abide to this system. So for us, I think it's going to be very interesting to see, so how are we going to redesign this equilibrium that they are asking for? And the second point I'd like to make, and it's in answer to Leon, I don't think that we should dream of having another Versailles Treaty. And although there were a lot of legal mechanisms and institutions which were quite creative and interesting, it was a very special time, not just because of the aftermath of the First World War, but it was also a time when you had peoples who were not considered as grown up enough so to be independent and so on. So there was a certain status of discrimination. But what I would like to say is that what has interested me a lot during this conference is the role of people. Think of Woodrow Wilson. I think he's someone amazing. Now, when he went back to the States, this was quite unfortunate because then he voted with the majority against the covenant. But at least he had brought this covenant on the stage. You spoke this morning of Jean Monnet. Jean Monnet has been an architect, which is just an incredible architect of the 20th century with the European institutions and so on. So, and then we saw the picture of Eleanor Roosevelt. Eleanor Roosevelt, she, I think, pushed a lot for the human rights to be included in the UN Charter and so on. So what I think is that we should maybe put more attention on people, persons, and what they can do. And I think they can do a lot.
No, sure. Certainly, people can do a lot, and momentum are not predictable. So, if you look back, I mean, when I began to study international law, I heard that the Vienna Convention of 1969 was what was called le champ du cygne des traités multilatéraux, but then people saying that were not able to predict what happened during the 90s, 30 years later. What is sure is that the time cycles in international law are that on one life for an individual or even more. So it's you have this kind of what Laurence called resilience of international organization. We can call inertia, because international organizations do not disappear. They can fall asleep, but they do not disappear, and they can be reactivated. We have already seen that. I mean, I'm able to identify one international organization which was completely suppressed, except for the League of Nations, but recently l'Union de l'Europe occidentale, which was absorbed in the European Union, but or else. I mean, international organizations do not disappear; they just fall asleep. So. For courts, maybe the issue could be different. When we raise the issue, all courts at threat. At the WTO, undoubtedly, were in times of crisis, but also in the 70s, I remember the paradigm to study international law was crisis, typically. And you had all these articles on crisis of international law, because international law was heavily questioned by third world countries. At this time, this is the way we were talking about this. And so, and then it was time for law of development, which disappeared completely from the agenda. And so imagine people who voted the new International Economic Order in 1974, what they would have thought in 1994, when the Marrakesh Agreement were concluded. I mean, in 20 years, you see this kind of revolution. So I'm not able to predict. Versailles, I don't wish so. I fully agree there. And in our mindset, we are not there anymore. But what we do here at the Institute, trying to connect international private law, public international law, and we have seen along this conference that this connection is not obvious even when talking about international courts, that the points of contacts and the use by the international courts of the conflict of laws, rules, and or techniques are not that obvious. And so we still have dead angles, and we still need to connect various problematics in order to have a more enlightened view on international courts. We have these issues. But what we see here is that a long time we have had law as an answer to problems. Instead of trying to provide a political answer, you go for a court to provide a legal answer. And you have this also at the domestic level, when governments answer political problems by making laws. So the substantive law as answers to political problems. We make a law, we provide an answer. And then we have the further step that we can see, procedural rules, in order to handle this substantive law, as if it was a way of providing a further answer to problems. And then you have to reflect to what extent it doesn't connect to a purely bureaucratic and managerial logic. And especially in this institute, I mean, this is a problematic which we have to keep in mind. What was striking during the various presentations was the speakers saying, oh, it took them only 45 minutes to make decisions. They just had a look at the file. But imagine, could you have, even if you're absolutely sure that this policeman has tortured this man, you cannot spend only half an hour on the case, because you have to go through the adversarial proceedings, the time limits in which each of them has to speak, the language in which they are spoken, and so on and so forth. And the time you have been through all the guarantees which have been set up, but which are also as many constraints as there are guarantees. And we have to reflect on this balance as well. So even if we had a momentum like Versailles, I don't know if we would be able to do Versailles now. For also for this reason. And last but not least, this photo, I agreed to have it. The problem is that the only woman you see is a painting. In the painting. So sorry, but Mamadou raised adequately that, it was very white. And I add, and he also said it's very male. So let's look for a bit more diversity of balance.
Now, what you say, I was thinking of what Herbert Kronke said yesterday, how UNIDROIT was created in 2 minutes after a stupid discussion about one word. This would not be possible anymore. I think also in Versailles you had also a very limited number of players who, although they had political differences, belonged to the same league. C'était le Concert des Nations, but a little later. But anyway, they were of the same type. Now, of course, with over 150 countries for different things, it's different. And by the way, I'm convinced that the Treaty of Rome, which created the European community, would no longer be able to be concluded now, because when people did it in the 56, I guess, 57, they did not know what they were doing. And by the way, the ratification of that treaty in the different member states was rather problematic, because people when it was ratified, people didn't know what they were ratifying.
So now we are reaching the moment when we are all, I think, tired. We have spoken a lot, exchanged a lot of ideas. We have, I think, exhausted the good ideas at this stage. If you... it's my feeling. So I think that it's time to thank the panelists for having exchanged these ideas, the audience for having shared other ideas and participated in the debate. And I thank you all for that. And then we will close this panel now. Thank you.
So this is a moment where you still have to listen to me, but I can reassure you. There are two approaches to the conclusions, and the one is the French one, and you might have heard about a rapport de synthèse. So this would take about half an hour. I have to make it elegantly, and I have to take up everything which has been said by everybody. And there is a more functional approach which says conclusions is about concluding a conference. And this is exactly what I would like to take up now. We had, I think we can say this, a very stimulating and interesting conference on 2.5 days. It was a good moment for the Institute. It was a good moment for the two departments. And of course, we don't know what the future will bring. We look back at the Versailles Peace Treaty, but what we do know is that in 2 years' time, there will be a debate about the Versailles Peace Treaty. And we were a little bit ahead in the time. And now I come to the flip side of the whole conference. There will be a book be published in the course of the next year with the contributions which were made for this conference. And the idea is, of course, to have the book the moment the next conferences about the Versailles Peace Treaties will take place. So all speakers are a little bit reminded and invited to hand in their manuscript by end of March of next year, so that we really can publish the book very timely in the book series of the MPI, and you will get very nice emails from Luxembourg in this respect. Now I have to close and to give some words of acknowledgement. So Hélène nicely said at the very beginning how we discussed the concept, and it was a conference of the two departments. But I have to say that especially your department was very much involved in the preparation of the whole venture. And I would like to mention two persons personally, Nathalie Perrin, who was really doing a great job in assembling all the different details, and Michel Appelding. He was not only a person who spoke today to a very interesting issue, but he was a little bit also a mastermind behind the whole planning in proposing speakers, topics, etc. You made it very well, so thank you very much. And finally, I would also like to thank the staff of the Max Planck Institute, the administration. It is fantastic for the two directors to have such a team. This is a possibility to organize conferences in a way which is very comfortable for all participants. If something went wrong, it's my fault, but I don't believe that anything went wrong. So I would like to mention two persons, Frau Logrillo and Frau Winkel. They really made a wonderful job together with all other people involved, the student workers, other staff of the administration, our IT people, and we are very much looking forward to have some videos on our YouTube channel, so you will get additional information about the conference, and you can review it if you want to do it. So thank you again, all speakers, all participants. I wish you a very safe way home and hope to see you very soon again here in Luxembourg.